Sorry, Judge, you're on mute.
Brad, can you hear me?
I can hear you, Jerry. I cannot hear Judge Timmons.
Same here.
All right, can you all hear me now?
I can.
Very good.
All right, this is the petition for a writ of mandamus that was filed by the State Board of Education. I have received and read the response that was filed on August the 10th. And with regard to that, I appreciate both of you all work on the case so far. I'm going to allow Mr. Clark to begin his argument with regard to the writ of mandamus and to tell me with specificity what I looked at your prayer for relief, what in particular your writ is designed to do besides compel Western Heights to comply with what the Board of Education requires them to. And whoever is on here, please mute your microphone so that we don't have any interference from those folks who are here just to listen. I would also let you all know that my court reporter is present to take testimony. Do you all hear those, the noises where people are wanting to join in? Are you able to hear those or not? Okay.
I don't hear anything, Judge.
All right. Okay. Mr. Clark, you may proceed.
All right. Thank you, Judge. Good afternoon. I'll start with the last portion of that. The prayer for relief is, I think, as you said, to request an order of the court compelling the school district to recognize and comply with the authority of the state, and I say state being State Department of Education, State Board of Education, State Superintendent. That in particular also would, as a condition of continuing accreditation, the State Board took action on July 12th to set some conditions as they had in April. Amended those conditions to add conditions to that continuing accreditation with probation. And so the request is to seek an order of the court requiring the district to recognize and comply with those conditions. I will not go into the facts too much here today. I'll try to be brief. I think Mr. Colclaser's done a really good job of briefing the issues. I think we've thoroughly briefed them, so I won't spend much time on that if I can. Happy to address any questions, but I think the short way to say, to open anyway, is the position of the state is that the state collectively is vested with the authority to supervise, direct, govern, credit, supervise, establish positions, determine policies, and oversee the public schools in the state. The district would certainly be included in that as far as our position is concerned. On July 12th, most recently, the state acted. The district said, and I might be paraphrasing a little here, but I think the district's position was, we will not recognize the letter, the action of the state board on July 12th without an order of the court. State requested an order of the court. District requested additional time, and so here we are today. I think there are three pretty straightforward questions as far as this first issue. The first being, does the state have a clear right to supervise, govern, direct the public schools? In our request, I think it's paragraphs 12 through 19, we attempted to set forth the authority. If the answer to that is yes, then the second question comes. And that question is the district refusing to recognize that clear right of the state to supervise, govern, direct, oversee the schools? I don't think that's really disputed at this point. I think the answer is yes. The district has admitted that they're not going to recognize that portion of the state's authority. The final question is there another remedy available? I don't think so. Not in the state's position, there is not. And that would be just one example to point to would be the district saying, unless we have an order of the court, you have no remedy. And I might just borrow an analogy here. In the district's response, I tend to think the position was there's not a specific statute in Title 70 that says the state board can order a district to put their desks apart 8 feet. Well, there's not. But just like with the courts or executive orders of the governor, there's Article 6, Section 2, which vests with the governor the executive power of the state. More locally, I think it's Local Rule 3 as a presiding judge over the district courts. And that judge is vested with the authority to supervise the courts. And I think we saw that over the last year or two with masking requirements, with spacing requirements, guidelines, directives to supervise the courts. I use that analogy because I think the statutes and the authority that we cited in paragraphs 12 through 19 are along the same lines. So with that, I'll pause.
Mr. Colclaser, at this juncture, I'd like to hear argument from you with regards to whether or not there is authority for the writ of mandamus that is set forth in the statutes.
Thank you, Your Honor. Can you hear me okay?
I can.
Okay, thank you. Well, of course, we couldn't disagree more with Mr. Clark. Let me start on the first issue, and that is whether or not the State Board of Education or Superintendent Hoffmeister have the legal authority to operate local school districts. And let me start, Judge, just with the example that Mr. Clark gave. The governor is the chief executive officer of the state of Oklahoma, and he can do a lot of things. But you know what? He can't go arrest somebody, even though he's the CEO, and even though he has powers over lots of law enforcement, he himself can't go arrest someone. He couldn't appoint someone to a position that the legislature didn't give him the authority to do that. And that's the issue. A state agency only has that authority which the legislature has given that state agency. And as we'll see in a moment, you can see that not only has the legislature given some of these powers to the State Board of Education, the legislature has also seen fit to take those powers away. And I think that's probably one of the most compelling things in this case. Let me start, Judge. The kind of the basis of all of who has the power in the state of Oklahoma comes into one statute. It's titled, it's at the very beginning of the school code, 1-115. The statute says that the administration of the public school system in Oklahoma is in 4 entities. 1, the State Department of Education. 2, the State Superintendent of Public Instruction. 3, Boards of Education of School Districts. And 4, Superintendents of School Districts. Now, the legislature didn't say or put a hierarchy there. They didn't say that these 4 are going to do it and that state superintendent should be the lead and everybody else defers to her. They gave 4 different entities, and 2 of those, it goes to the local control. In Oklahoma, we have local control in our system, and the statute is set up. And if you don't believe that, look at the powers that the legislature has given these 3 entities. First, what powers have they given the local school boards to operate a local school district? And I'd point out, Judge, we're not trying to operate the State Department of Education or the superintendent. So the only issue is what powers do they have to come and operate this local or any local school district for that matter. And the fact is, if you look at the powers that in the different powers and duty statutes that each of these have, both local school districts, state superintendent, and the state school board all have statutes that give them what powers and duties they have. And if you look at first with the local school district, they have the power, and Judge, this is pretty all-encompassing. Number 3, they have a power to maintain and operate a complete public school system of such character as the Board of Education shall deem best suited to the needs of the school district. That's a pretty wide discretion that's decided entirely by the local Board of Education. Of course, it goes on to have some 24 other powers and duties, elect its own officers, they get to make rules, they get to contract and fix the duties and salaries of teachers, superintendents, and then they go on again and they say, perform all functions necessary to the administration of a school district in Oklahoma as specified in the Oklahoma School Code. And then it goes on to say, certainly we can't supplant other legislatively given duties and powers of others of the other 3. So Judge, if you look then, if you compare that to the power of first the state superintendent, look at her power and duty, and that's in 70 OS 3-107.1. She has the power to organize and control the administration of the state superintendent. They limit her to the state superintendent. It doesn't say of local school districts. She has the power of have general supervision of all employees. And again, this is important, Judge, of the department, not the local school districts. And that's pretty much it. The state superintendent has a lot of general supervisory coming up with accreditation and issues, running the Department of Education. But does she have, for example, the ability to employ folks that work for the local school districts? The answer is no. Does she have the authority to hire a superintendent for a local school district? The answer is no, it's not listed. We next look at the state board, and that's a little bit more encompassing, and it's set out in basically 4 categories. The operation of the education department, which doesn't affect local school districts, directly. The issuance and the revocation of teacher and superintendent licenses, the promulgating rules and regulations for public education. And keep in mind, Judge, the legislature is who decides and sets the guidelines for those rules and regulations that are later promulgated by the state agencies. Now, I think that the first thing I point out, there is no statutory authority in the statute anywhere like the local school districts that give the State Board of Education the opportunity or the power to operate a local school district. It's not there. Nowhere in the powers and duties of the State Board of Education does it give them the power to run and operate a local school district, as the statute for local school districts says, in the manner that they deem fit for the operation of that district. It's just not there. Now, I think one of the things, Judge, that probably is one of the strongest arguments here is that some of the powers that the state board would like to have today, and that they've asserted and asked you to issue a writ of mandamus to order the district to succumb to that takeover power and that employing persons in the district power. Part of that they used to have. Back in 1999, under No Child Left Behind, the legislature gave the power to the state board to reassign district personnel, to transfer students. This is the important one, to operate a school by personnel employed by the Department of Education. Those were powers that the legislature gave to the State Department of Education. The problem is, Judge, is 10 years ago, the legislature killed those powers. They stripped the State Department of Education of those powers and changed it essentially to where no longer could the state board take over local school districts, run local school districts. From that point forward in 2009, if you look at Title 70, 1210.541, the 2009 version, the state board went from having some operational power in local school districts under very specific circumstances to having none other than advisory, assistance, and certainly maintaining the accreditation in another statute. The fact is, we don't believe that the State Board of Education has the power or the duty to operate local school districts. We have 5 locally elected Board of Education members in Western Heights, as all of the other 700 school districts have in Oklahoma, and they have locally elected officials to run those boards of education. And the State Board of Education can certainly set some standards. They can also, after a full individual proceeding, they can decide whether or not those standards have been met. That's only after a hearing, I might add, and the court's well aware of my position on that. But they can do that. What they can't do is go in and operate a local school district. Specifically, they can't employ a person to be the local interim superintendent or a teacher or anything along those lines. They can't force a local school district to take their discretion with regard to how to operate a local school district and replace it with the State Board of Education's discretion. Secondly, Judge, the question comes in terms of whether or not to suspend the superintendent. The other thing that Mr. Clark didn't talk about in too much detail, and I won't go into much detail either. I briefed that in my brief. If you can call it a brief, it's fairly long. I apologize. Judge, the problem is that essentially there is a statute that defines superintendents as being teachers. And that's kind of the gist of the problem, is because we've got a statute that says teachers include teachers, custodians, superintendents, everybody. And then we've got other statutes, specifically the Teacher Due Process Act, that refers only to teachers. And it doesn't mix it up with superintendents as well. And the issue here is the statute that Mr. Clark and the State Department of Education are relying upon is Section 6-101L. It's a fairly new statute that was just changed 1st of July. And it says that a teacher, and I'd point out the statute says teacher, whose certificate was suspended by the state board, shall be placed on suspension pursuant to the provisions of Section 6101.29. Now, it's at this point, Judge, and I'm on page 30 of my brief. It's at this point that, not brief, 30 of my answer. And it's at this point that the house of cards kind of starts falling apart. Because if you look at Section 6101.29 of the Teacher Due Process Act, you'll see, and if you review all of the Teacher Due Process Act, you'll see that it only refers to teachers. And it becomes utter nonsense if you try to insert the word superintendent where the word teacher is, which is what the State Department of Education is arguing here. Because Section 6101.29 requires superintendents to suspend teachers. The statute says, whenever the superintendent of a district has reason to believe cause exists for the dismissal of a teacher and is of the opinion that the immediate suspension of the teacher would be in the best interest. Well, Judge, that statute is specifically for teachers, because otherwise, if we're supposed to substitute the word superintendent for teacher, then that statute would read, whenever the superintendent of a school district has reason to believe that cause exists for dismissal of a superintendent and is of the opinion that immediate suspension of the superintendent would be in the best interest, going on and on. It becomes utter nonsense at that point, Judge. That statute is intended to apply only to teachers, and it addresses a situation that only the local boards of education have the ability to do that. You may recall we've argued and briefed this issue that that the State Board of Education by statute have no statutory authority to suspend anyone. They only have statutory authority to give a certificate and revoke a certificate. In any event, Judge, and I know you disagreed with that, and I recognize that. I certainly respect your opinion in that, Judge, not further arguing that, but I wanted to point it out that it comes back to haunt us in this statute that teachers and superintendents are completely different. And this is where we come into another reason that the court should not grant a mandamus. As I think you pointed out, if it's discretionary, and mandamus is if it's a discretionary issue, then the court should not intervene in something in which the lower board, in this case, the Board of Education, has the discretion. And in this case, there is a statutory scheme for the suspension and termination of superintendents. And as the court knows, specific statutes trump generalized statutes. We would submit that the statute that deals with the suspension of teachers generally is a general statute, where the statute that deals directly with suspension of administrators and superintendents is a specific one. And in that case, the local Board of Education, I'm referring to Title 70, Section 6101.14 that I've reproduced on page 32 of my brief, Judge. Whenever the local Board of Education or the administration of a school district has reason to believe that cause exists. Now, Judge, as you know, reason to believe that cause exists screams of discretion. That's something that you're asking the local board to decide, does cause exist? And then secondly, and when they are of the opinion that the immediate suspension would be in the best interest of the children. Secondly, it screams discretion. That's up to the local board to decide that. Then the local board has the ability to suspend. It's a discretionary act. The Board of Education, it is seated solely in the Board of Education. You'll notice in this statute, Judge, there's nothing in here that allows the State Board of Education to come in and make either of those discretionary determinations. Only the local board. We submit, Judge, the fact that it's discretionary means that it's not appropriate for mandamus, and that completes my argument on the mandamus, Your Honor. Thank you.
All right. I think that the statutes that are more specific with regard to the suspensions of superintendents is a statute that is separate and apart from the Teacher Due Process Act. And I think it's pretty clear that there are two separate actions and two separate procedural requisites. With regard to the petition for the writ regarding the State Department, I think that there is ample authority for the fact that the State Board of Education has superintending and governing control over local public schools and the local public boards of education. That's found in Oklahoma Constitution, Article 13, Sections 5, 70 OS, Section 1-105, and 3-104. It is also found specifically in 70 OS 3-104A1, 6, 7, 13, 17, and 20. And here's what it says. It says that the State Board of Education has the authority in matters pertaining to licensure and certification of persons for instructional, supervisory, and administrative positions in public schools of this state, that they have the right to promulgate rules governing the classification, inspection, supervision, and accreditation of public nursery, kindergarten, elementary, secondary schools in the state, which means they have the duty and the right to supervise. They have the authority to require persons having administrative control to make regular and special reports regarding the activities of the schools in said districts, as the board may deem needful for the proper exercise of its duties and functions. They have the authority to provide for the health and safety of the school children and school personnel while under the jurisdiction of school authorities. They also have the authority and are required to perform all duties necessary to the administration of the public school system in Oklahoma, as specified in Oklahoma School Code. In addition thereto, those duties not specifically mentioned herein, if not delegated by law to any other agency or official. They are required to adopt standards for accreditation. They are required to provide for warnings regarding accreditation, probation, or if they're going to go into non-accredited status for schools that fail to meet the standards. In regard to that, they are required to implement corrective plans and intervention plans through the State Department of Education that is given to the local school boards for compliance. It is clear to me in this case that that is a non-delegable duty that is not arbitrary, it's not capricious, it is not discretionary. It is mandatory under the law. If the school district under subsection D at 70 OS 3-104.4C, if a school does not take action to comply with the accreditation standards within 90 days, the state board shall withdraw accreditation of a school. There are separate procedures for challenging the State Board of Education's suspension of the school superintendent, and those can be found under the Administrative Procedures Act. And in this case, once that suspension occurred, I read the correspondence between the State Board of Education and the school district, and there is at one point a complete refusal on behalf of the school district to comply with any of the requests or the mandates or the supervision of the State Board of Education. And that simply is not allowed by law. And I think it's clear it's not. There are complaints with regard to a number of different issues that to me are troubling. That after the school board suspended the superintendent, the school board, in complete derogation and ignoring of the State Board of Education's suspension, instead of following the Administrative Procedures Act, which would have given Mr. Barnes, the superintendent, the ability to appeal that and put on evidence, they basically said, we're not going to do that. We're going to give him a raise and encumbered almost $1 million of funds and a $25,000 performance bonus in a move designed to completely thumb their nose at the jurisdiction of the State Department of Education, despite the fact that in March and April of this year, numerous and troubling deficiencies were found and laid at the doorstep of Mr. Mannix Barnes that are attached to the defendants, to the Western Heights Board of Education response. In particular, there is a report with regards to funding that was used in a way that appears to be incorrect. I don't know if it's illegal, but it was improvident. It appeared to be a bad business decision, which cost the district a bunch of money in terms of how much they paid for the finance charges and fees and interest. That even Carrie Patton, which is an exhibit attached to the defendant's response, it's exhibit number 7 on page 76, Carrie Patton from Western Heights criticized the use of the money and the fact that it was not a good business decision on behalf of Western Heights, to the tune of about $8 million that was spent paying off a 2003 in a 2018 lease and a 2009 lease. Well, I used the 2018 money to pay off a 2009 and 2013 lease purchase agreements. And she said that what happened was they had to use $8,000 to pay off those leases and increased the financing funds that Western Heights had to pay as a result of it. And let me give you what gave the court particular pause. It said, because lease purchase financing funds are not revenues to be appropriated, it is my conclusion that the school should not be using that money to pay off other lease purchase financing agreements. So not only did she say that the payoff of those was to the financial detriment, she didn't think that the funding source was what they ought to be using. And this is from somebody at Western Heights. When I go further into the exhibits that were attached to Western Heights' response, I find a letter from American Fidelity with regard to the insurance accounts. And Mr. Barnes' response basically was that the financing issues, we stopped doing the software and that we had used before, that they had put in place before I got there, changed it over in approximately April of 2020. But he's been there since 2020. And the deficiencies found were deficiencies that were done in June of 2021, where they say that March, April, and May, they have the records for that. March does not balance. And they said they were current to May of 2021. So they're talking about issues that with regard to paying the insurance for the employees into American Fidelity that were still ongoing under Mr. Manick Barnes' watch as of June 14th of 2021. As recently as the last hearing, there were issues with the bus system and the fact that there weren't buses that were operable. There was a state fire marshal's report that said that the fire system, suppression system wasn't working correctly, and there was a citation issued by the school. So when we talk about issues that are within the purview of the district, that is squarely one of them, to suspend his license, which means he's probably still getting paid, but to put somebody in place who can remedy those things in time so that those kids, when they go back to school, have what they need and they're in a safe environment. It's also a discussion about the special ed program, which had a level 3, which is needs intervention. That they were found to need intervention. And as early as April of 2021, they are still working on a corrective action plan for that in the district. And these are not problems that just cropped up yesterday. These are problems that have been ongoing at Western Heights. So when I look at the statute, and the statute that to me clearly gives jurisdiction of the State Board of Education to go in and correct these ongoing problems. They didn't just crop up yesterday. These ongoing problems, it is clear to me that Western Heights either fails to realize it, doesn't care, and is persistently refused to make corrective action and report those corrective actions in a timely way to the Board of Education, the State Board of Education, who clearly has the right, statutorily and constitutionally, to oversee local school boards. Clearly has that, based on the statutes that I've cited, and also the statutes cited in the State Board of Education's brief and writ for mandamus. And so the court is going to grant the writ of mandamus with regards to the actions of the school board, the state board, against the State Board of Education. And I'm going to rule that the request made by the State Board of Education in their prayer for relief is granted in total, that the local school board is required to provide the acting interim superintendent that was appointed by the State Board of Education access to everything that he needs to do the job that he needs to do to get the school up and running in time for school to start on the 18th. And it is telling to me that after Western Heights does an affidavit that says Miss Race is not competent, is not qualified to be superintendent, that after the State Board of Education appoints a qualified person to go in and straighten up what appears to be this mess in Western Heights. And I'll say it might not be, I'm at the beginning of this case, but it appears to be a mess financially, operationally, and in every other way I can think of that these poor parents are worried about sending their kids to school at, that after that happens, they appoint Miss Race, who just did an affidavit and said that she does not have the experience and capability to be superintendent. Now, I don't know what anybody else would call that, but I call that a blatant disregard for the State Board of Education's authority, a blatant disregard for the welfare of those children at that school and that administration and staff. I was appalled by that. And so at one point now she's qualified when Mr. Barnes gets suspended. But beforehand, she did an affidavit that said she wasn't qualified. That bothers me. That bothers me because you can't turn around and say two different things when it suits you to say so. And the fact that that happened to me gave me great pause about what's going on with that school board. If they're going to say one thing 10 days ago and then another 10 days later or 20 days later, because it suits their fancy to change their narrative on what's going on in that district. It means that they have a whole issue with credibility in terms of what's going on there and their ability to fix it. I have a problem with that. And then I saw letters and emails where the State Board of Education requested their presence, compelled their presence, so they could talk to them about what's going on, what needs to be done, and they refused to go to the State Board of Education meeting. Refused to go. That to me is I don't understand. At a minimum, go and talk about what's going on and make sure that you're doing what's best for the children of that school district, even if you don't like what they're saying. But to refuse to go at all was improvident, and it was a decision made that I don't have any earthly idea why Western Heights thought that was a good idea. I don't. Send somebody. I mean, you got to talk to people. If you're really interested in what's best for those school children, go find out what's going on and try to remedy that. The complete abdication of any responsibility to answer to the State Board of Education when they're calling, asking for answers and asking for cooperation and work between both entities, to me, was foolhardy on the part of Western Heights. And it told me as a judge that they're not going to cooperate. They have no intention of cooperating in a way that's in the best interest of those children there and in a way that's going to get this school ready for school to start. So I believe that those are exigent circumstances, that it is clear to me that Western Heights has a duty to respond and are under the supervision of the State Board of Education under these circumstances. And they have wholly and abjectly failed to abide by the State Board of Education's requests, requirements, and dictates set out in order for them to help Western Heights turn around this school district that has been apparently from the documents submitted that I saw from Western Heights themselves, had numerous issues with compliance in a number of different areas. So I'm sustaining the writ. I am advising Mr. Clark that under the statute that I can award you the cost of this action upon proper motion, and also a reasonable attorney fee upon proper motion for the attorney fees that were reasonably incurred with regard to the actions and inactions of Western Heights and the writ of mandamus that had to be filed to compel their performance and get their school in compliance with the State Board of Education mandates, and which would be also in the best interest of these children. And so I'm going to sustain the writ. I'm also going to sustain the writ with regard to Mr. Barnes and the actions of the Western Heights School Board that gave him a performance bonus and encumbered almost $1 million is something that I will visit at a later time if necessary, if that action becomes one that imperils the funding mechanism of that school. Court will be in recess.
Judge, if I may, Judge, there's some
Yeah,
issues
question.
that need to be addressed. Judge, housekeeping issues. I'd like to indicate to you and make sure we need to cover issues with regard to the automatic stay of your judgment.
It'll
I'm
be
sure,
denied. It'll be denied. I don't-
Judge, if I understand you may deny it, but I think I have a right, Judge, to just present that to you so the Supreme Court later won't say that I didn't present
You
the
did.
statutory authority for an automatic stay, which is Title 12 OS Section 66, as
You're
well
not
as,
entitled to an automatic stay. You're entitled to ask for a stay.
I
Entitled to
understand,
ask
Judge.
for a stay. And my response to that is it'll be denied because we have approximately on the August of 18th is when school starts. So the stay will be denied at the trial court level. And it's my understanding that you can ask the appellate courts to stay it, but the stay will be denied. And part of the reason for that is we're close to the school session to begin. And I think it'd be a detriment to the school children to stay this matter in the current condition that Western Heights is in. It's going to put those kids at risk and their education at risk. And so your stay is denied.
Thank you, Your Honor. Appreciate it.
You're welcome. Court will be in recess.
Have a good afternoon.
Yep.
You all do too.